Seaworthiness in autonomous unmanned cargo ships. Evolution of seaworthiness. The following chapter aims to present the evolution of seaworthiness under a historical perspective. The purpose is to highlight the significance of the concept by indicating that seaworthiness is as old as the maritime law. The Oxford Dictionary of English defines seaworthiness as the good enough condition of a boat to sail on the sea. From a maritime law perspective, there is no unique definition of seaworthiness, and not only one understanding is to be found in the legal instrument. As a general observation, it is common ground that seaworthiness is the ability of a ship to sail on the sea, and more specifically the sufficiency of the ship to face the perils of marine adventure. However, two observations shall be made. Firstly, seaworthiness is an absolute condition capable of fitting in all voyage and all type of cargo. Secondly, the term of seaworthiness doesn't include only the physical state of the ship, but also encompasses other factors. Therefore, from a legal point of view, it is not always clear whether a ship shall be defined as seaworthy. In the following chapters, we will thoroughly scrutinize the usage of seaworthiness in maritime law. This particular section will present a further analysis of the doctrine historical development. To understand and interpret seaworthiness, it seems reasonable to step back into the past and view the root of the doctrine. As far as the history of law is concerned, it can be clearly stated that each legal rule has been created and modified to meet specific commercial and financial needs. Accordingly, the doctrine of seaworthiness in maritime law was formed and developed to protect the different interests exposed to the perils of the marine adventure. The first body of maritime law is to be found in Rhodian Sea Law, which stipulates the maritime ethic in Mediterranean. There was no general obligation of the ship owner to provide a ship in a good state and condition. However, a seaworthiness provision is to be found in situations where great and valuable cargo were loaded on ship. More specifically, merchants are recommended to ensure that the ship owner provide a ship in a good state with its proper tackle and a sufficient number of skillful mariners. However, this provision wasn't binding but operated as a mere recommendation, avoiding no legal consequences to the parties involved. Similar provision can be found in Byzantine charter parties. In the same way, there was no explicit obligation on the ship owner to provide a seaworthy vessel, but the charterer was only recommended to inspect the condition of the ship, the tackle, and the number and sufficiency of the mariners. Notably, the number of seafarers increased following the size of the ship. It is a matter of significance that unlike the Rhodian Sea Law, heavy penalties were imposed on the ship owner for any deficiency in the ship's tackle. Turning to the laws of Oleron in 1336, which is admitted to be the foundation of all the European maritime codes, the seaworthiness of the vessel was stipulated as an explicit obligation of the ship owner. More specifically, two provisions are to be found regarding the physical condition and the manning of the ship. Firstly, by virtue of Article 11, the ship owner had the obligation to show the condition of the ropes, cordage, and slings to the merchant before the commencement of loading. Notably, the ship owner was liable for any damages caused by such deficiencies. Secondly, under Article 13, the ship owner had the obligation to provide a properly manned vessel, and furthermore, he was liable for damages resulting from the insufficient manning. Moreover, similar provision concerning the crew members are to be found in the Wisby rules. While running the hourglass of time 500 years after the laws of Oleron, a seaworthiness stipulation is also included in the body of marine ordinance. More specifically, in virtue of the relevant provision, if the merchant proved that when the ship put to the sea she was unfit of sailing, the master shall lose his freight and pay the other damages and losses. Consequently, the seaworthiness obligation is absolute since the mere unfitness of the ship that exposed the vessel to the risk of marine adventure is sufficient to establish liability. Secondly, the wording unfit of sailing is more subjective and non-descriptive in comparison with the previous aforementioned legal instrument. As a conclusion, the following considerations are to be made. Firstly, the meaning of seaworthiness started as a recommendation for the cargo interest to observe the condition of the vessel and gradually developed and maintained as an obligation upon the ship owner. This development illustrates that the commercial practice historically required the presence of the seaworthiness obligation upon the ship owner. Secondly, it is clear that the meaning of seaworthiness under the historical perspective isn't static but constantly developed. Therefore, it could be arguable that the legislature formulated the meaning of seaworthiness in a manner to fit the changing circumstances and to respond to the commercial needs. Thirdly, it is also perceivable that a significant aspect of seaworthiness is the manning of the vessel. A seaworthy ship, in order to face the perils of the sea, is required to be manned with skillful mariners. Seaworthiness in carriage of goods. The following chapter aims to present the seaworthiness legal framework as presented in the carriage of goods and to highlight the human element as a significant aspect of seaworthiness. Moreover, this chapter will present the significance of the concept by pointing out the legal consequences from an unseaworthy ship. This chapter scrutinizes the current understanding of seaworthiness under the carriage of goods by sea in international maritime law. The first part will examine the implied obligation of seaworthiness under the common law. In the second part, a further analysis of the seaworthiness doctrine under some principal international carriage convention will be given. In the third part, the implication of seaworthiness in charter parties will be presented. By way of introduction, a general definition of seaworthiness is essential to be given. According to Tapley, seaworthiness may be defined as the state of the vessel in such a condition, with such equipment, and manned by such a master and crew that normally the cargo will be loaded, carried, cared for, and discharged properly and safely on the contemplated voyage. The implied obligation in common law. In principle, either a bill of lading or a contract of affreightment will include or refer to a provision regarding the obligation of the carrier to provide a seaworthy vessel. In absence of an express stipulation, every contract of carriage of goods by sea is subject to an implied seaworthiness obligation under the common law. Firstly, it is essential to determine the nature of the carrier's obligation. Under the English common law, the carrier has the absolute duty to provide a seaworthy ship. Therefore, even if the carrier proved that he took all the reasonable precaution to provide a seaworthy vessel, he will be still liable if he failed to provide a seaworthy ship. However, the meaning of seaworthy is relative, which means that the vessel shall be fit for its purpose. In other words, the carrier is under the obligation to furnish a ship capable of sailing for the particular voyage, carrying the particular cargo and fit to encounter safely the expected perils of the sea, taking also into consideration the nature of the ship significantly. Thank you.